Welcome to the January 7th, 2025 regular meeting of the San Ramon Planning Commission. We are calling the meeting to order at 6 p.m. Okay. Item 2, roll call. Can the recording secretary please conduct the roll call?
Commissioner Alpert,
Here.
Commissioner Wallace,
I'm here.
Vice Chair Curtis,
Present.
Chair Kuznick.
Yes, I am here. Okay, move on to item 3, the Pledge of Allegiance. So if you'll stand and join us in the pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, very good. Item 4, public comments or written communications. At this time, members of the public may address the Planning Commission on any item not already included in tonight's agenda. If you would like to speak, please fill out a speaker card located in the back of the room and submit it to the recording secretary. We will not be taking any public comment via Zoom. Do we have any speaker cards?
No, and no written public comment for this item.
Okay, very good. Okay, moving on to item number 5, additions and revisions. Do we have any changes? Seeing none, moving on. Item 6, the consent calendar. Item 6.1, minutes of the Planning Commission regular meeting, December 17th, 2024. Do we have a motion to approve?
I'll make a motion to approve the minutes from the Planning Commission meeting on December 17th, 2024.
I will second.
Was there any public comment on the consent calendar?
No.
Okay, sorry. Reading, okay, here we go. We have a motion and a second. And the minutes have been, we've been accepted 4-0. Thank you. All right. Yeah, missed a page here. Item 7. Continued items after the close of public hearing. There are none. Item 8, continued items. Open the public hearing for Woodside Canyon Residential Development. We have a staff member to start us off.
Good evening, Chair Kuznick and Planning Commissioners. So this is the Woodside Canyon Development Project located 18 Crow Canyon Court. The project would demolish the existing office building, parking lot, and landscape on site. It would construct 54 for-sale multifamily townhome condominium units, provide 121 parking spaces on site, and provide comprehensive landscape on site. Lastly, the project will also subdivide the project site into with a vesting tenant map for condominium purposes. The commission may remember the Planning Commission held a public hearing on December 3rd, 2024 for this item, where you received public testimony, provided some comments to the applicant and staff, and adopted a motion to continue the public hearing to tonight's meeting. So staff has prepared a revised draft resolution that's attached to the staff report with some red line edits to the previous draft resolution and conditions of approval. The revised resolution and conditions have been reviewed by the City Attorney's Office and with all the included supported revisions by the Attorney's Office. So staff recommends that the Commission receive the staff report, open the public comment, tape public testimony, close the public comment, and close the continued public hearing, discuss and deliberate, and adopt the draft Planning Commission resolution number 01-25 to approve the project applications. I'll turn it back over to the Commission.
Sorry?
I'll turn it back over to the Commission.
Thank you. Are there any questions yet? No, okay. So I'm going to go ahead and open the public hearing for this item. Is there public testimony for this?
Written public comment was received from Dylan Casey and James Lloyd with Cal HDF and Jim Blickenstaff. I have not received any speaker cards for this item.
Okay, very good. So, seeing. Okay, come on. Come on up. And then afterwards, if you could do the speaker card for us.
Yeah, sorry, I just got here late.
Yep.
Good evening, Chair, Vice Chair, Commissioners, and City staff. My name is Max. I'm a resident of Windermere Ranch, where my family and I have lived for 17 years. I just want to say that I wholeheartedly support this project. It's great to see more housing in San Ramon, especially in the old city center. I think it's a good contribution to our city's RHNA goals. It's obviously in a great, more accessible location. I just want to let the city know that there are people in the city who do support more housing in order to address the Bay Area's housing and affordability crisis. If we're up to me, I'd honestly build more units, probably reduce the parking spaces a little, but I'm not the commissioner. But either way, I just want to express my support for this project and thank you for your good work. That's all.
Thank you very much. And then Lucas will help you in the back. Thank you. Okay. Seeing no other public comment, I will close the public hearing portion. And commissioners, we will discuss and deliberate. So, gentlemen,
I have some.
okay. Commissioner Wallace, why don't you start us off?
In this case, this matter, the applicant has asked for 1 concession and 3 waivers of our development standards. When I originally planned on coming here, I thought, okay, we'll just deal with those issues. Let me give you some background on why I am extending a little bit beyond that. In September of this year, I sent a memo to the city attorney asking for his advice regarding how waivers and concessions would be processed in the city, including who would make that decision on those items. In November, the city attorney responded to my memo, sent me a copy of the memo, and also copied staff and each of us on this dais. I looked over the city attorney's memo. I determined that, in my view, it was incorrect in a number of areas. And last month, I wrote him a memo explaining why I disagreed with him. After I did that, the city attorney informed me that although he had sent his memo to the Planning Commission, I could not do that, and neither could he, because apparently to do so would be disclosing the thoughts of a commissioner, and that would be a violation of the Brown Act if it was outside the context of a public hearing. After our last hearing on this matter, I thought the issues were pretty much limited to the stoop question that was raised at that hearing, and I pretty much forgot about a number of things relating to concessions and waivers, particularly because last week I asked the city attorney if he intended to respond to my memo, and he advised me that he was going to sometime this week. So I basically backburnered that whole idea. While preparing for this hearing over the weekend, I realized that staff had written a number of comments about how concessions and waivers are processed and the standards for doing so. And in my view, a number of the statements in that discussion are inaccurate. It's a matter of public record now because it's part of the staff report that is part of the public record. And I did not feel in good conscience that I could allow statements that I felt were inaccurate, as I explained to the city attorney in my memo, to go without some discussion. This will lead to a discussion of the specific waivers and concessions that the applicant has asked for, but I may mention this in a introduction because I want you to bear with me on what I have to say, because it took a fair amount of time to go through staff's comments and try and come up with, as a lawyer, a succinct way of analyzing them. And this is something we are going to have to deal with every time a housing application comes in, because I do not believe there is going to be a housing application submitted to this commission anytime this year that does not involve some request for a concession or waiver on the part of the applicant. Now, what I'm about to say assumes that the applicant has met the basic requirements for a density bonus, which is the provision of a certain level of affordable housing units. In this case, I'll start with one density bonus. That gives the applicant one concession, the ability to ask for one concession and get one concession, but unlimited waivers. Now, in the staff report, it basically conflates concessions and waivers and talks to them about them as if they were Tweedledum and Tweedledee. In fact, they are very different concepts that have different standards and different consequences. In the case that the staff cited in its memo, Schreiber versus City of Los Angeles, the Court of Appeal described a concession, which is also referred to as an incentive, as, quote, a reduction in site development standards or a modification of zoning code requirements or architectural design requirements that results in identifiable and actual cost reductions to provide for affordable housing units. When you boil it down, that involves two different things. The first is that absent the granting of the concession, the project is inconsistent, let me repeat, inconsistent with city standards, because what they're asking for is a reduction in development standards or modification of zoning requirements and other things, which means in simple English that the project doesn't meet those requirements. The second is what is required to grant a concession. It's not that the concession will make the project financially feasible. It's a much lower bar. It's simply whether granting the concession will result in cost savings to the applicant. Now, that's a pretty damn low bar. I mean, it's hard to think of a developer who wouldn't really ask for concessions if it wouldn't save them some money. And because it's such a low bar, that's why the legislature only allows one concession for one density bonus. Now, a waiver is a totally different thing. A waiver is described in our density bonus law, the state density bonus law, as a development, as saying that the city cannot enforce a development standard that will have the effect of physically precluding. Let me repeat that. Physically precluding the construction of a development in accordance with what the design is. Now, physically precluding has nothing to do with financing. It has to do with the physical structure of the project. There are 3 points that are important. The first is, like a concession, a waiver only is sought because the project would be inconsistent with city development standards unless it is granted. Second of all, a waiver is not required to be granted unless enforcing the particular development standard physically precludes construction of the housing project. Now, as you know from all the time we spent talking about objective design standards, and for those of you who were here when we talked about it in connection with the San Ramon Village Specific Plan, there are many standards that apply to construction of housing in the city. Not all of them are deal breakers. We have design standards that apply to how you make a window. Now, that's a design standard, but it's inconceivable that a developer would be able to get a waiver under these circumstances simply because he doesn't like the way the city requires windows to be recessed. Third, unlike a concession, the issue of whether a waiver will result in cost savings to the applicant is irrelevant. As the Schreiber Court itself stated, there is no financial criteria for granting a waiver. Now, in the connection with waivers and concessions, the issue came up between myself and the city attorney as to who decides whether to grant it. And there is actually a very simple explanation. Last fall, the city staff asked the commission to recommend to the city council that it adopt a density bonus law for the city. Consistent with the staff's recommendation, the commission made that recommendation to the city council, and the city council adopted that density bonus law in December of 2023. Part of the density bonus law that was drafted by staff states that, quote, application for a density bonus incentives, concessions, and/or waivers shall be considered and acted upon. Let me repeat that. Considered and acted upon by the decision-making body with authority to approve the housing project, close quote. In connection with housing projects in the city of San Ramon, including this one, the Planning Commission is the decision-making body for approval of housing developments. Consistent with our city's density bonus law, that means this commission, not staff, determines two things. One, does the project qualify to ask for a density bonus? The second, and maybe more important, is the applicant entitled to be granted either a concession or a waiver? Now, I think it's important to note what the process is for a concession or waiver coming in front of this commission. Obviously, there's a housing development application that's submitted. That's the first step. However, under the city's density bonus law, an applicant seeking a concession or waiver in connection with that housing development must submit a written request for a concession or waiver from the city's development standards that is processed along with the housing application itself. Now, our density bonus law has a description of what is required for a concession, which is a description of the requested concession. For waivers, however, there is a much more detailed explanation of what the application is required to tell the city. It requires, quote, an explanation of the waivers or reduction of development standards requested and why they are necessary to make construction of the project physically possible. Again, the waiver request has nothing to do with the financial aspects of the project. It has to do with whether the project can be built absent the granting of the waiver. Now, as all of you know, the way an application is processed under the Housing Accountability Act, which also includes the density bonus law, is that the city is required to notify an applicant within 30 days after the application is deemed complete. Provides them two things. One is to identify any provisions of the development standards that the housing project does not comply with. And second, provide an explanation of the reason why the city considers the housing development to be inconsistent with city development standards. Now, this letter has often been referred to as a, quote, consistency letter, close quote. In fact, it is the opposite. What the HAA requires is not a letter saying your project is consistent, but a letter that says if it's not consistent, to tell the applicant why. Now, at that point, at the time that letter is issued, the request for a concession or waiver that was submitted to the city along with the housing application itself has not been acted upon by the Planning Commission. In fact, it is never even submitted to the Planning Commission for a formal discussion. Since the request for a waiver and concession has never been considered or granted by the Planning Commission at the time the inconsistency letter goes out, it would be improper, in my opinion, for the letter to state that the application, the housing project, is consistent with city standards, because until that request for a waiver or concession is granted, the application, the housing project, is not consistent with city standards by definition. So how should that 30-day notice go out? First, it's not that hard. First, it should identify to the applicant the nature of the concessions and waivers requested. Now, since the applicant has already identified the concessions and waivers in its application, that's pretty simple to pull those out. Second, the notice should state, consistent with the Housing Act, should state why, absent granting the waiver or concession, the project will be inconsistent with city standards, since the application from the applicant details what standards it wants eliminated. That's pretty simple too. And here's the part that I think is really important, and I have mentioned this to the city attorney before. The third thing that should go into that letter is a notice to the applicant that pursuant to the city's density bonus law, the concessions and waivers requested will be presented to the commission for a decision at one of the public hearings permitted to the commission under the Housing Accountability Act. Now, as you know, under the Housing Accountability Act, for which density bonus projects are a part of, the city is entitled to a total of 5 public hearings. By tradition, we have set aside the 5th one for the city council in case someone is unhappy with our decision, which does happen occasionally. But we have also set aside a hearing occasionally to allow the Architectural Review Board to weigh in on the housing project. But that still leaves at a minimum 3 public hearings for the Planning Commission to review concessions and waivers. Now, the housing application comes with a statement from the applicant as to what waiver it wants and why, and what concession it wants. When a public hearing is held, there will be a staff report that, again, reiterates that. The applicant comes in and provides whatever color it wants as to why it should get the concession or waiver. And at that point, the commission has an opportunity to ask of both the applicant and staff the factual basis upon which the request for a waiver or concession is being sought. And that sort of leads into what staff wrote in its present report. The first thing in the staff report that deals with concessions and waivers states that quote, the requested concessions and waivers are presumed to result in cost reduction necessary for the feasibility of the project, close quote. Now, as a matter, that's not a correct statement. First of all, the density bonus law for purposes of the concession character does not make financial feasibility of the project an issue that is necessary for a concession. In fact, the Schreiber Court that the staff cited to in its report says, quote, a showing that an incentive is needed to make a project, quote, economically feasible, close quote, relates to the overall economic viability of the project and is not the same as showing the incentive will result in cost reductions, close quote. So the issue for a concession is not that the project will be feasible, but will that particular concession result in cost savings? For a waiver, the issue of feasibility from a financial standpoint is irrelevant because the standard for granting a waiver is not economic or financial feasibility, but can the project be constructed with the waiver not being granted? Now, the staff report goes on to say, quote, density bonus projects requiring concessions and waivers need not prove that concessions and waivers will result in actual cost reductions, close quote, but rather local governments may either accept this presumption or provide substantial evidence to the contrary, close quote. Now, in connection with a concession request, the law basically says that once a concession request is made, there is a rebuttable presumption that if the concession is granted, there will be cost savings. In other words, to deny a concession, the city is required to prove that cost savings will not take place if the concession is granted. Now, there are other factors that can be used to deny a concession, but they are almost impossible to meet. For waivers, however, the issue of cost reductions is, again, irrelevant because that's not the standard for granting a waiver. It's whether the enforcement of the development standard will physically preclude construction of the project. The Schreiber Court, which is cited in the staff report, specifically says, quote, "There is no financial criteria for granting a waiver." The third thing the staff report goes on to say is that the Schreiber Court determined that local governments are not required to conduct any analysis prior to granting the request. To the extent that simply means that making a request creates a presumption that it is entitled to be granted, I would agree that that's probably what the law allows. But the Schreiber Court didn't say anything about the city not making an analysis of whether the concession or waiver was appropriate. In fact, the Schreiber Court went on to say specifically that a city could do its own investigation regarding court savings. It said, quote, "A city or county is not prohibited from requesting or considering information relevant to cost reductions," close quote. Now, this gets into what the Planning Commission's role is in determining requests for concessions and waivers. As I pointed out, the language of our density bonus law says that the Planning Commission is to consider and act upon a request for a waiver or concession. The language "to consider" means that the Planning Commission must take into account the factors that would justify granting either a concession or waiver. To me, that clearly requires the Commission to make some type of inquiry regarding the factual basis that would support the granting of a concession or waiver. Now, in the Schreiber case, the court did not discuss what is required or what the city can do for a waiver, because the issue in Schreiber was the argument that the financial considerations were required for the granting of a waiver, which the Schreiber Court said, of course, that's not the case. The same factors that the Schreiber Court pointed to in terms of granting or considering the grant of a concession clearly apply to a waiver, and even more so. In the concession request, the standard is, will it result in a cost savings? Pretty low bar. Doesn't take a lot of evidence to support a finding on that. But the issue on a waiver is whether, if our standards, if our objective design and development standards are enforced, does that physically preclude the creation of the project? That is a different standard, and to me that requires a further investigation of the factual basis for the waiver. We are allowed to do that clearly at a public hearing because the applicant is in front of us and can answer questions, as they did at the last hearing on this project. If we need more time, as happened on this project, we should have the ability to do that because we have at a minimum 3 hearings to discuss and decide these actions. And remember, what we are being asked to do is to jettison objective design and development standards that we have spent, in some cases, years developing. And I think that our city deserves some type of investigation by the Planning Commission more than just a short shrift potted plant activity. The staff report goes on to say that concession and waiver requests are to be accepted as financially necessary on face value. Now, I'm not sure what to be accepted as financially necessary on face value means. If it means in the context of a concession that the request for a concession creates a presumption that the concession is necessary for cost savings, that's one thing. But the Schreiber Court, as I pointed out, says that a city is not prohibited from doing its own investigation as to whether the concession will result in cost savings. Now, that's even more true in the case of a waiver because, as we pointed out, there is nothing in the waiver context that deals with or requires any finding regarding the financial effects on the applicant of denying a waiver. Again, it is clear from the Schreiber case that the city has the ability to make an inquiry about whether the waiver is necessary in order for the project to be physically completed. And that's supported by the density bonus law that staff asked us to recommend to the city council. The last comment of staff that I want to mention is the quote that, quote, concessions and waiver requests are adequate for determining consistency with any local adopted ordinance, general plan element, specific plan, or other local condition, law, policy, resolution, or regulation, close quote. In my view, that is directly contrary to what the law is and how a concession or waiver operates. First of all, by definition, when an applicant seeks relief from an objective city design or development standard, that means that the project as designed is inconsistent with the provision for which relief is being sought. It is inconsistent, no pun intended, for someone to say that because a request for a waiver or concession is made, that makes the project consistent with city standards. It's actually 180 degrees different. If the point to the quote was to say that by making a concession or waiver request in the context of what the city is required to do in its 30-day notice, that the fact that the applicant requests a waiver or concession, which by definition has not been granted when that notice goes out, is in of itself a signal or a statement or a finding that the project as proposed is consistent with city standards. Given that that application by definition for a waiver or concession does not been granted when that letter goes out, it is, to me, improper to say that the project is consistent with city standards. Remember that a concession or waiver doesn't change the city standards. A waiver is by definition a forfeiture of the right to insist upon performance of the contract. Therefore, granting a waiver and concession doesn't change the standard. It simply tells the applicant, we're not going to enforce this particular standard against you. Sally may come in and ask for a waiver, but we may not grant that. The simple way to look at it is this. Bob wants to build a 50-unit apartment complex. Our city standard requires a 10-foot setback from the front of that apartment building. Bob wants a 8-foot setback, and he asks, because he qualifies for density bonus, for the city to waive its 10-foot setback requirement. When the city agrees to grant that waiver, we're not changing our city 10-foot development standard. What we're saying to Bob is, for you, we're not going to enforce that. And that's much different than saying Bob's project is consistent with city standards. It's saying that we're going to give you absolution for meeting that standard because of state law. So how do we deal with the fact that our applicant here, who's been patiently waiting to get to this point, has asked for one concession and 3 waivers of our development standards? The concession has to do with the path that would otherwise be required under the San Ramon Village specific plan to go towards the creek. During our last session, upon questioning, the applicant testified that it would in fact save money if it didn't have to build the path. We also had submitted to us drawings showing what would be built in place of the path. And I think that for purposes of this project, that there is sufficient evidence upon which the applicant can be granted a concession from the multi-use path requirement of the specific plan request. Now, the applicant asked for 3 waivers. 2 of them were discussed at the hearing, and that I did not see any really discussion suggesting that there were a problem with them. As I recall, at least one of them had to do with the setback requirement for the front of the property, where we had a setback, I believe it's 10 feet. The applicant wanted to modify that to 14 feet because putting the building at the 10-foot setback requirement would actually encroach upon an easement that was illegal for it to do. Now, what came up, the original staff report said that the real issue was the fact that although our specific plan calls for a steps going into the units, what the applicant proposed was actually a level-in approach, that there wouldn't be any stoops. You would be able to walk straight into it. Now, that is what I saw at the Ryan Industrial Court townhomes that we approved a number of years ago. However, that approval was done well before the San Ramon Village specific plan was adopted. Now, at the hearing, Mr. Hale mentioned that the ADA would not apply. As I pointed out, the American with Disabilities Act, the federal act, did not cover this type of building. But he indicated that there was California law which would require them to have a level-in approach into at least some of the units. I believe the figure he gave was 10%. Now, I had asked whether we could get some specification of what those plans were. I didn't get it, so I took it upon myself to send an email to Mr. Hale last month asking him for some citation to the part of the California Building Code that covered that particular requirement. And on December 20, Mr. Hale did send me an email which identified that. And I would like to hand this, and I would like to have a copy of Mr. Hale's email made a part of the record in this case, because it's important, I think, to show that in considering the request for a waiver, the Planning Commission did its own inquiry and followed up with questions to make sure that there was a factual basis for granting the waiver of this particular issue, which was the level-in approach to the buildings. And although it's not that easy to do, I was able to pull up a copy of the California Building Code that Mr. Hale referenced in his email, and it's found at Title 24 of the California Code of Regulations. Chapter 11A deals with multi-story buildings, of which this particular project is an example. It's not only multi-story, but it's multi-family, because there are a number of units basically bolted together. They're not true single-family detached homes. And in section 1102A.3.1 of the California Building Code, chapter 11A, title 24, it does require, as I read it, and as Mr. Hale indicated at our last meeting, that at least 10% of the units are to be accessible to disabled persons. Now, if you look at the figures that are associated with that particular section, what it is clear is that what the code is aimed at is people with wheelchairs. Because if you look at the type of entrances to those buildings that are deemed acceptable, they all involve ramps so that there is a straight path into the unit for a disabled person. To me, that is consistent with the level-in approach that is being asked in this particular project. And even though the applicant has asked for all the units to be so designed, instead of limiting to 10%, it is my view that that is an acceptable waiver, and that granting that waiver, along with the other two that were requested in Table 4 of your narrative submission back in November, is appropriate. So I think that given this, the commission has done, for the purpose of the concession requested by the applicant and the 3 waivers requested by the applicant, has done the type of inquiry and investigation that our density bonus law requires us to do. And I think it is appropriate to grant the concession and the waivers that the applicant has requested.
Questions, discussion, gentlemen?
So if I followed, you're comfortable at this point if we move forward and review the resolution and the conditions of approval as presented at the dais?
Yes, you don't even have to twist my arm to do that.
Okay, so I suggest, because I have no questions, unless Commissioner Curtis or you have questions, I'd like to move forward with reviewing the resolution and the conditions.
I think we can do that. And I appreciate Commissioner Wallace's effort to make sure that we were hitting the mark on all of our requirements, both as a commission and as the applicant. So appreciate your patience on this topic. All right, here we go. Resolution is our standard here. We look at page by page and note that some of the enumeration has been redlined and upgraded. So on page 13, do we have any changes or corrections to the resolution? Hearing none. Page 2 of 2, which is packet page 14. Hearing none, we will continue on to packet page 15, page 3 of 9. I think we have that corrected, the dates and timelines on that. Okay. Yep, looks good. Page 16. That looks like pretty much our standard resolution information. Okay. And again, on to page 17. Okay. Concerns? Nope. Okay. We're finishing page 17. There's 2 red items. We're good on both of those. Okay, moving on. Page 18.
I have a comment or two that I'd like to bring to the commission's attention. The first, in what was previously numbered as subparagraph C, we have retained some language that's redlined in there, but it is not clear to me what the numbering of that paragraph will be. So I would assume that when this is placed in final, the paragraphs will be numbered consecutively, so we don't have to worry about that. The second thing is what is now listed as subparagraph D. Now, this is the paragraph that grants the concession and the waiver that's referred to. I want to have some changes made in this, not from a substantive standpoint in terms of not granting the waiver or concession, but 2 things. The first is the reference to the concession for the San Ramon Valley Specific Plan Multi-Use Trail Standard, I think is incorrect, because what the basis for granting is making that if we don't, the proposed project will be physically infeasible. As I've pointed out, that is not the standard for granting a concession. It's that granting the concession will result in a cost savings. The second part of the paragraph that I think needs to be changed has to do with the waiver. The waiver that's described in current paragraph, subparagraph D, relates to one waiver, which is, quote, fence height, building porches, setbacks, I think. Now, I'm not sure if setbacks is referred to the 2 waivers that are in Table D, but I think that we should make that clear, that it relates to both the waivers of the setbacks, so that there are really 3 waivers. Now, what I propose to do is this. We would keep the substance of the paragraph, but we'd basically rewrite those 2 sentences. Now, there's 2 ways we can do this. What I would propose to do first is to read the language that I would like substituted into existing subparagraph D, and I will then hand to the panel and staff a written copy of what I'm about to read into the record, so the record is clear as to what I'm proposing and hope that the commission accepts. With respect to the concession, here's the language I would propose to insert. Quote, applicant's request for a concession under Government Code Section 65915, paren K, close paren, of eliminating from the project, with a capital P, the SRVP multi-use trail standard contained in SRVSP figure 6.5, as described in Table C of applicant's project narrative received October 18, 2024, would result in actual and identifiable cost reductions for the project and is therefore granted under Government Code Section 65915, paren small d, close paren 1, close paren, period. Now, this differs from the language that is used in the staff report. 65915D1 is what grants the concession request. D2 that's referred to in the staff report actually doesn't deal with granting it. It describes how many concessions an applicant is entitled to receive for one density bonus. If you look at the paragraph immediately preceding it that I was referring to first, which is originally labeled C, it does describe the one concession that's permitted under the government code, and it references Government Code Section 65915D2. And I think that's sufficient. To put that into the actual granting of the concession, to me, is redundant. With respect to the requests for waivers, I would propose this language, quote, application of the SRVP development standards described in Table D of applicant's project narrative received October 18, 2024, would have the effect of physically precluding the construction of the proposed project, period. Applicant's request for a waiver of those development standards is granted under Government Code Section 65915, paren small e, close paren 1, close paren, period, close quote. I think by specifically referring to Table D of the applicant's narrative, project narrative, it specifically identifies what those waivers are. And I think that is more consistent with what's required under our density bonus law.
Okay.
So that being said, I would like to pass along to the dais the actual language I just read into the record, and hopefully that will help. If the commission decides that that language ought to be adopted, it will help the actual drafting of the final resolution.
Any discussion before we head off in a different direction here? So just so that I'm clear, back on page 18, we are agreeing to what is added in paragraph B, the stuff that it was added, what looks like to be a paragraph C. And then what is currently called C, you're okay with that? And then we're going to go to these two paragraphs as D.
Well, it'd be renumbered. Let's see, there'd be
D.
A, B, C, pardon me for speaking,
That's right.
D. And so what I just read into the record would be new subparagraph E.
E.
And then you have to renumber the next one to make
Right.
it F.
Okay.
Like it
Okay.
F.
Just a question, Commissioner Wallace, on the second paragraph, which I guess will become E. You mentioned application of the SRVP development standards.
Emerald Valley.
Which?
Specific.
Second paragraph,
S-
application of the
SP.
SRVP, should that actually
Oh,
be
okay.
SRVSP?
Well, what that shows is I really suck at typing.
That's okay.
It
That's
should
okay.
be the acronym that's been used throughout the resolution, San Ramon Valley Specific Plan.
Okay. Okay. I'll just share. In general, I'm okay. However, I don't have a copy of the San Ramon Village specific plan in front of me to confirm the figures, nor do I have copies of the government code. So with the indulgence of you all, pending staff and city attorney's office confirming the right sections of government code are captured and the right sections of the specific plan are captured. I'm okay in general with
Yeah.
expanding the narrative for a concession and a waiver. But I'd like to let staff finalize the language there, and I don't need to see a review. I don't need to review it a second time. You know.
Obviously, I don't have a problem with that. With respect to the figure that I cited, that's what appears in Table C of the project narrative. That's the identification point. That's why I put it in the draft resolution.
That part's okay. It's just where we reference the figure 6.5 of the specific plan, as, the table part of it, I have the letter from the narrative from the applicant. I just don't have the specific plan here.
Again, the figure 6.5 is in the applicant's table, but I can understand that.
Mhm. Yeah,
Through the chair, the government code references are correct. I can't speak to the exhibit in the San Ramon Village specific plan at this point, but we can verify.
Yeah,
I believe it is correct because I went and looked prior to tonight's meeting and I think that's the diagram that I actually copied out to bring tonight. So
Okay.
I believe 6.5 is correct. Okay. Going to page 7 of 9. I think we only have some minor amendments there. And then we get to page 8 of 9. Okay, very good. Okay. This is the part that, remind me, do we go through the conditions next or vote on the resolution? I'm sorry, I don't recall.
You can go through the conditions, but you don't need to go really page by page. They are for most standard conditions of
Okay.
approval. So at this point, I ask the commissioners to move the resolution.
Okay, all right. Anybody have objections to just deciding on the resolution
Along with the conditions of approval
with the conditions of approval? Correct. Thank you so much.
As
All right.
amended on the dais.
as amended on the dais.
Yes, thank you. Okay, so gentlemen, is there someone who would like to make a motion?
All right, since I'm the one doing all the talking. Since I'm the one doing all the talking.
Get all the glory. All the glory.
Okay. All right, I would move that the Planning Commission adopt resolution number 01-25, approving the Woodside Canyon Development Project, DP 2024-0002, TRP 2024-0008, MJ 2024-0001, and environmental 2024-0001 located at 18 Crow Canyon Court, including the modifications made on the DS during this hearing and adopting Exhibit 1 to the proposed resolution.
Is there a second?
I will second it.
Okay, very good. We will take a vote. And we have adopted the resolution. It has passed 4-0. So go forth and build. You're welcome. Okay, let me find my agenda here. Okay. All right, here we go. Item 9, public hearing, new items. There are none. Item 10, non-public hearing action items. There are none. Item 11, study session, commissioner liaison reports, and interest items or staff reports. Do we have any? It's kind of early in the month for reports, but go ahead.
So back in December, I actually attended the Transportation Advisory Committee meeting, and it was a relatively straightforward meeting. They had a presentation on, an annual presentation from County Connection on how the buses are doing in our city.
Very good.
And the good news is they're back to pre-pandemic with the exception of business travel, business bus usage.
Mhm.
But weekends are doing well, and that was the PAC meeting of December. That's all.
Wonderful. Great. No, all right. Let's see. Okay. Anything, all right, we get to the point where staff, do we have some updates?
So at this point, we're actually looking at a couple of changes to the calendar, but what I can say is January 21st will likely be canceled. We do have a study session coming up in the not too distant future, as well as some other work related to the zoning ordinance text amendment and the like. In addition, there's a joint City Council Planning Commission meeting scheduled for February 11th to deal with the DMU North FAR question. And so that'll be coming your way, or at least currently we're looking at that date.
Is that DMU North or DMU South?
North.
North?
And so we'll be firming these dates up in the next week or so. It's early in the month still.
Okay. Okay, very good. Anything else then for the good of the order? All right, well, thank you, everyone.